Before we get into today's chat, quick one. If you're not 100% sure how your HR is really holding up, take our free HR health check. It's short, jargon-free, and gives you a clear score on what's working and what needs a bit of love. And if you do it before 1st April 2026, you'll get a bonus 7-pillar strategy on a page, tailored to help you manage HR brilliantly for the year ahead. Just head to kateunderwoodhr.co.uk/HR-health-check the link in the show notes. Picture this. It's 8:15 on a soggy Tuesday morning. I've just popped into a local indie design agency to grab a decent Americano and overhear a bit of real-life HR drama unfolding. The owner's sliding across the floor in socks, waving a half-unplugged laptop and shouting,
"Do we actually have to do sexual harassment training now? I thought that was just for the BBC or companies with actual HR departments."
Meanwhile, the junior designers knocked over a mood board, the office dogs chewing through a USB cable, and I swear I hear the whoosh of a tribunal deadline flying past. Now, just to be clear, this is not one of my clients. My clients already know about this law. They've had the update, the policy, and the training plan sorted months ago. That's the beauty of having me in your corner. It's one less thing to think about. But if that scene feels even a little bit familiar, then this episode's for you. Grab your brew and stick with me, because by the end, you'll know exactly what the law says, why it matters, and what you should be doing right now to stay compliant and protect your people. Welcome back. Kate Underwood here, buzzing at you from Shock, a sunny New Forest. You're listening to Buzzing About HR, the podcast for small business owners, accidental HR folk, and anyone trying to run a decent, compliant workplace without drowning in jargon. Show notes and links are online, so no frantic scribbling required. Let's get into it. Part 1. Setting the scene. Back in October 2023, the Worker Protection Amendment of Equality Act 2010 Act was passed. The big change? From October 2024, employers now have a legal duty to take reasonable steps to prevent sexual harassment at work. And here we are in June 2025, nearly a year into enforcement. So let me ask you, have you actually done anything about it yet? This law is about prevention, not reacting after a complaint, not hoping it never comes up. It's about being proactive, creating a culture where harassment isn't ignored, tolerated, or brushed off as banter. Part 2. Real sexual harassment cases you need to know about. Let's look at what's been happening in real workplaces across the UK, because this law isn't hypothetical anymore. These are real tribunal cases with real financial and reputational consequences. Case 1. Tesco, 45k payout. Part-time worker Lara Story made a complaint of sexual harassment. Tesco investigated. They upheld the complaint, but the colleague stayed. She was left feeling unsupported and ultimately victimised. The result? A $45,000 settlement and some very public headlines. Lesson? Just saying you support someone isn't enough. You have to act and protect them once they speak up. Case 2. Salon text messages. At a small London salon, the owner repeatedly messaged a junior stylist with inappropriate comments, flirty emojis, comments about her appearance, late-night jokes about her love life. She told him it made her uncomfortable. He laughed it off. Then her hours were cut. The tribunal said sexual harassment and victimisation. The award? Just over £18,000. And remember, his intention didn't matter. What mattered was her experience. Case 3. Just banter isn't a defence. A female engineer in a manufacturing company was subject to ongoing sexual jokes and suggestive comments from a male colleague. She complained. Management told her to lighten up. She took them to tribunal and won. £25,000 in compensation and a clear warning from the judge that banter isn't an excuse if it makes someone feel humiliated or unsafe. These aren't extreme situations. They're everyday examples, and that's exactly why this law exists. Part 3. What you should be doing. Now, let's talk about you. If you're thinking, okay, but what does reasonable steps actually mean for my small business? This is your bit. Start with a proper, up-to-date anti-harassment policy, not something copied and pasted from a free template in 2016. Make it readable, relevant, and actually used. Next, training. It doesn't have to be formal or fancy. Host a team session, use examples, get people talking. It's not about ticking boxes, it's about making it real. You also need safe and accessible reporting routes. If someone's only option is their manager, and that's who they're reporting, then they've got no route at all. Offer an alternative, another senior, an external contact, even an anonymous form. And then there's culture. Policies and training are great. But if your culture says we laugh it off, or it's just how Dave is, that's where the problem lies. And last but not least, keep records. If you're doing training, updating policies, or having conversations, make a note. It all counts. Part 4. What to do when a complaint lands. Here's the moment everyone dreads, but don't worry, we've got this. If someone raises a concern, step 1, listen, privately, without judgment or interruption. Step 2, write it down, stick to facts, who, what, when, where. Step 3, don't make promises, just reassure them it'll be taken seriously. Then, decide what happens next. Is this something that can be resolved informally, or does it need a formal investigation? If it's formal, investigate properly. Speak to both sides, be objective, stay fair. If it's too close to home, bring someone in. Then, decide and act. And ask yourself, what do we learn from this? What can we put in place to stop this happening again? And of course, follow your policy. If you don't have one yet, make that your very next step. Part 5. Myth busting and mini dramas. Time to bust some myths. These are real things I've heard this year. We don't do training. Then it's time you started. This is one area you can't afford to skip. It's just banter. No, not if it makes someone uncomfortable. It doesn't matter how it was meant. What matters is how it lands. We've never had a complaint. That might be because no one feels safe enough to speak up. We're too small. There is no size exemption. If you employ people, this law applies to you. Part 6. Listener Q&A. Right, let's get into a few of your cracking questions. Q. If it happened on a work night out, does it still count? Absolutely. Work socials and work responsibility. That pub garden is still on you. Q. What if it was a customer, not a colleague? You still have a duty to protect your staff. Deal with it. Q. Can we handle it informally? Sometimes, yes, but only if the person affected agrees, and you still need to document it and follow up. Q. What if the accused is a manager? You must have an alternative reporting route, always. Q. Do we have to do this every year? Ideally, yes. Short refreshers go a long way and show you're staying proactive. Got more questions? Keep them coming. I may do a bonus episode just for this. Part 7. Buzzword of the week. Proactive prevention. That's what this is all about. Don't wait for the complaint. Don't hope it never happens. Take action now and you'll thank yourself later. Part 8. When employers get it right. Let's end on a high. A local retail business I know, not a client, just someone doing the right thing, had a staff member raise a concern about inappropriate comments from a regular customer. What did they do? They took it seriously, banned the customer, updated their training, told the team, "We've got your back." Another small company I know, 12 staff, no HR department, ran a training session over coffee and croissants, reviewed their policies, and created an anonymous reporting option. 6 months later, someone used it. The issue was handled calmly, fairly, and privately. Both people felt heard, and trust in the business grew stronger. It doesn't take bells and whistles, just care, intention, and a plan. Final thoughts and a pep talk. You don't need to be perfect, but you do need to be prepared. This law isn't just about compliance, it's about decency. It's about creating a workplace where people feel safe, respected, and able to focus on their actual job. And if you're thinking, right, I need help with this, that's what I'm here for. Pop over to kateunderwoodhr.co.uk or message me on LinkedIn. Let's take this off your plate. That's it for today's episode of Buzzing About HR. If this helped you, share it with another small business owner. Leave me a cheeky review, or just send it to someone who still thinks banter is a culture strategy. Until next time, stay buzzing, stay brave, and remember, prevention beats panic every single time. Bye for now. That's it for today. But if you fancy a bit of friendly HR advice in your inbox with zero waffle, come and join our newsletter. We send out bite-sized tips, plain English updates, and handy things you'll actually use. No spam, no fluff. You can sign up at kateunderwoodhr.co.uk/newsletter-sign up, or just hit the link in the show